Thank you very much, ladies and gentlemen, for making your way into the Island Ballroom for this next panel discussion. As you can see, the panelists together with our moderator are already on stage. I'll just do a quick, brief introduction of who they are. We are pleased to introduce the moderator of this panel for the future of international dispute resolution, challenges and opportunities for access to justice. Our moderator is Mr. George Lim, Senior Counsel Chairman, Singapore International Mediation Center. Now, Mr. Lim was President of the Law Society of Singapore from 1998 to 1999, and has been named by renowned publications as being among the world's leading commercial mediators. He was also Singapore's mediation consultant to the UNCITRAL Working Group 2 on dispute settlement, which led to the Singapore Convention of Mediation. Now, with him, ladies and gentlemen, we have Professor Gabrielle Kaufmann-Kohler, President, International Council for Commercial Arbitration, the Honorable Justice Anselmo Reyes, International Judge, Singapore International Commercial Court, the Honorable Justice Edward Togbor, former Judge of the High Court, Kenya, and visiting academic, University of Oxford. With such an illustrious panel right here, ladies and gentlemen, on stage, I'm sure you will certainly enjoy this session. We now hand over the floor to George. All yours, sir.
Thank you. Good afternoon. Is this a good day? This is a historic event, and we're all part of that. Isn't it wonderful? Isn't it wonderful? Yeah. Now I feel like Madonna. All right. We have a bit of crystal ball gazing to do today. But before that, I just want to tell you that I've got a fantastic panel here. The panelists have said, do away with titles. No judge, professor, whatever. First name basis, right? So we have Edward. Anselmo.
Gabrielle.
Okay, wonderful. You know, I was part of the UNCITRAL group, 4 years of meetings in New York and Vienna. And I will tell you that, are there anyone in the audience who were at UNCITRAL? Who was at UNCITRAL? Michelle, you were there. I see Michelle. Right. Would you have thought years ago, when we had our arguments in the UN, that this would happen today? 46 countries signing. No? Okay. Can I ask people in the audience, and I'm going to address people of 40 years and above, 20 years ago, okay, did you have a mobile phone? Anyone had a mobile phone 20 years ago? A couple of people, right? Brad, you're too young. Okay. And today, I'm going to ask the audience, all right, those who have mobile phones, raise your hands. Everybody has a mobile phone, almost everybody, right? Okay, this is the change in technology. And can you imagine life without the mobile phone today, without your smartphone? Quite difficult. Bindula, how many times do you look at your phone a day? 4 times, okay. Bindula is from Fiji. All right, so today we are going to talk about the future of international dispute resolution. And our panelists will help us on this. Let's do a bit of crystal ball gazing. What's it going to be like? Okay, there have been a lot of changes. And we've been asked by the organizers to break up our discussion into 3 subtopics. The main topic is the future of international dispute resolution, challenges and opportunities for access to justice. So we're going to talk about some of the changes, structural or otherwise, okay? Mainly positive, I think, and what type of challenges and opportunities they present for international dispute resolution. We're going to break into 3 discussion points. And from the previous session, I think we all agreed that you are a lively audience. You want to ask questions, right? Right? Okay. I think you all are still having your lunch break. We would like it to be informal, to be interactive. So if you have questions, we welcome them, even during the discussions. Okay? So we're going to do it this way. We're going to start with talking about sources of dynamism in the international landscape and their impact on the use and shape of various dispute settlement processes. So changes, new structures, what does it mean? And then we're going to move on to perspectives on mixed modes of dispute resolution and combined dispute resolution approaches. So hybrid processes, I think that comes to mind now, arbitration, mediation, met up. And then the third subtopic, how dispute resolution and its use have changed and will change in the face of new technologies. Okay, especially example ODR, artificial intelligence. So the disruptors of today, and what will that mean for international dispute resolution? Okay, got the three sub-points? Changes, dynamism, okay? Changes, sources of dynamism, first topic. Second topic, mixed modes of dispute resolution, hybrid processes. And then the third point, how technology will disrupt all this, for good, for the better, or for the worse. Okay, so I'm going to begin by asking each panelist to start on a subtopic, and then we'll pause and we'll invite questions or even input from the audience. Okay, we've got an hour and 5 minutes left. I'm going to try and keep this fluid, exciting, lively, and with your help, we'll do that. Okay, Edward, you want to kick off?
Yes.
With the first subtopic, sources of dynamism in the international landscape and their impact on the use and shape of various dispute settlement processes. All yours, Edward.
Thank you very much, Lim, and good afternoon to you all. Sources of dynamism, to my mind, would include principally the international legal instruments and tools which have been crafted by very well-organized groupings of experts. We've heard a lot about the ancestral model law, the ancestral as an organization, and its massive contribution to the international legal order. And here I refer specifically to the model law. The model law has influenced arbitration in Africa in particular quite profoundly. But we know that the model law is a partial law, which means that there are areas which it does not cover. The positive thing is that the numbers of countries in Africa that have enacted the model law are making greatest use of it. But the gaps in it, which can be filled, are still creating problems. By gaps or omissions, I have in mind things like multi-party arbitrations. I have in mind arbitrability. Some national statutes define arbitrability, namely what is arbitrable and what is not. Others don't. Those who don't have clarification of arbitrability therefore face the problem of finding a way, leaving too much for the judges to decide whether or not a particular dispute is arbitrable. That, in my view, increases judicial intervention rather than limiting it. Then there are the other areas like describing the capacity, duties, and immunities of arbitrators, and giving the arbitrators power to make substantive remedies like injunctions. These are gray areas, and it's very important for a decision maker to know the extent of their powers and how best to use it, bearing in mind the kind of dispute that they have to decide. The question of interest on awards is also an omission, and it can be addressed quite simply. There are various rules dealing with interest, simple interest, compound interest, etc., etc. We can talk about it as and when we have the opportunity to do so. I'm offering myself to contribute to Answer Charles' work because I can spot the difficulties, the areas, the gaps in the law where the judges are struggling with. So I can contribute to this in discussions with Answer Charles, if I'm allowed to do so. Where Answer Charles has scored quite reasonably, in my view, is with regard to the 2006 amendments, which made amendments enabling topics like interim measures of protection to be dealt with. It has been a worrisome and very difficult area, but since the new 206 amendments, I think this is working quite well, and it's a very useful addition to what is there already. Don't be worried that I'm turning my notes. I've got a substantial amount of notes. I'm not going to read it to you, so don't be worried about it. But we are talking now in the context also of investor-state arbitration. The ISDS which leads into another very important instrument, which is the New York Convention. But before I say another word about the New York Convention, I want to clarify that the international dispute settlement system is based on 4 assumptions. The first assumption is that the bilateral treaties, BITs, the multilateral treaties, the North Atlantic Treaty and the Asian ones and so on, they do promote trade. And this is a very, very important thing for them, which means that they benefit from the trade and the investments that go with them. So the first assumption is that these international instruments contribute to trade. The second assumption is that states benefit by offering promises to investors. And thirdly, therefore, the investors also have an opportunity to bring their investment into the states. So that is another important inroad into working out the modalities, the best modalities for the international trade systems.
Okay, I'm going to ask you to pause there. Thank you.
Yeah.
So Edward has raised 2 important points. I think the first point was about, and you're talking about arbitration, right? Model law rules.
Yes.
And he's saying that it's good because a lot of African states have taken it up, but he feels that there are some areas which require reform.
Yes.
And he's offered his services to UNCITRAL. Corinne, are you here, Corinne? Yeah, Corinne, you've got a volunteer. And he's not going to charge, right? Edward? Okay.
Speak for yourself.
Thank you for that. And the other point is very interesting because he's talking about investor-state disputes. Some of you will know that the UN, UNCITRAL, has started Working Group 3 on investor-state disputes. And the first session was in April in New York, okay? And record, I'm not sure, Corinne, is it record? 107 states were present at that working group, okay? So the poor chairman, hard time, 107 states, and everybody wants to have a say, but it's exciting because, and I saw a lot of African states there, this affects the economies of the countries. You know, if you're going to invest in that country, if you have a dispute with the government, who's going to hear that dispute? So that is another big area, I think, for arbitrators, for mediators, for lawyers. Okay, thank you, Edward. I'm going to move on to Gabrielle, perhaps on this area of sources of dynamism.
Yeah, it allows me to just follow up. Yeah, in general, the question is about the sources of dynamism in international dispute settlement. And dispute settlement is reactive, like law. It simply reacts to the changes of the world in which we live. And so you watch the world and you see where the changes will occur with some time lag in international dispute settlement. And of course, investor-state dispute settlement is a good example of that because the reform initiatives came up at a time when there had been a shift in economic and political power in the world, with emerging economies gaining much more political economic weight and therefore showing different perspectives about investment arbitration. And at the same time, you also had the return of the state as a result of the financial crisis of 2008, was more importance given to state regulation after an era of deregulation. And so you see in treaties more and more an insistence on the power to regulate, and that also impacts in terms of dispute settlement reform options. And the third change that I see that impacts now the reform options on investment-state dispute settlement are linked to the progress of democracies in the last decades in the world and the increased aspirations towards democratic values. And you probably all know that democracies do trust in institutions and do not trust in non-elected individuals, such as, for instance, arbitrators. And that well explains that the idea emerged of some structural institutional reforms, for instance, by way of imposing an appellate body over the existing investment arbitration tribunals, or doing away with our investment arbitration and creating a court. And you have the similar distrust of non-elected individuals as arbitrators in different areas as well. I see, for instance, the creation of international commercial courts, like for which the SICC is, of course, a front runner, as another manifestation of this distrust of individuals and distrust in institutions. There would be more examples, but maybe I stop here because I've promised to be short.
Okay, interesting. So, Gabrielle, do you know she's regularly ranked as one of the top 10 arbitrators in the world? You all didn't know that. I joke with her about that, but it's true. So, Gabrielle has talked about, if it's state disputes, that perhaps there's now this perception that you need some other independent body, right? You use the word distrust, but maybe, I don't know, too strong? Appropriate?
Well,
maybe
it
a perception.
depends whom you
Yeah.
listen to. There are some critics that are very vocal and express some distrust. I don't think it is a generally shared.
So I think the fact that there's a working group on this by antitrust means that there is some concern, and I'm not, I don't think anything is cast in stone, but I think that the talk is about setting up some independent body, right? To either hear the cases or hear appeals.
The talk is more complex than that because there are also lighter options of reform that are simply trying to improve the existing system. And that will certainly be followed as well, and states probably thereafter will choose either a heavier option or a lighter option of reform.
Okay, thank you. And she's also raised the rise of the international commercial courts. And that's maybe, Anselmo, I'll ask you to talk about that because that's something new. And so how does that dynamism interact with our other forms of dispute resolution? Yeah, Anselmo?
Thank you very much. I have 3 points to make. The first one is on what are the sources of dynamism for the future, sources of dynamism that exist today and that will make for a dynamic future. Second, what sort of dynamic transformation is now taking place right at this present? And third, I'd like to talk a little bit, I'd like to say something about what the implications are for us in this audience today, not tomorrow, not in the short term, but right now. What should we in this audience be doing? The first, what are the sources of dynamism in the future? We've heard from Edward that there's the UNCITRAL model law, there's the New York Convention. We've heard about the Singapore Convention. We heard about that all this morning. I'd like to put some stress on the 2019 Hague Convention that was signed at The Hague on the 2nd of July. So we now have conventions dealing with the recognition and enforcement of arbitral awards, the recognition and enforcement of judgments, and the recognition and enforcement of mediated settlement agreements across borders. That's an element of dynamism for the future. Those are not the only elements. Gabriela has mentioned the rise of particular institutions to take advantage to ride on these conventions. For instance, my court, Singapore International Commercial Court, the SICC. In terms of arbitration centers, arbitration institutions, they are rising all over the world in areas where you might not expect it. For instance, this weekend, I'll be lecturing in the NCAC, the National Commercial Arbitration Center in Phnom Penh. Cambodia wants to position itself as a regional or sub-regional arbitration center. There are mediation centers that are sprouting up. For instance, in Kyoto, where I teach at Doshisha University, there's the Japan International Mediation Center. There are many mediation centers that are rising, and there are tie-ups being instituted, for instance, between the Japan International Mediation Center in Kyoto with SIMC, with what George is in charge of. So these institutions are rising to ride the wave of these conventions. They're rising all over. This leads to the question, are there too many institutions for dispute resolution arising to ride the wave, chasing too few dispute resolution processes? There are not enough cases to fuel these innovations, these sources of dynamism. The second point that I want to raise is I think one should welcome all this interaction between these various sources because they lead to competition. Competition amongst international centers, competition in arbitration, competition mediation, competition between different modes of dispute resolution, mediation, arbitration, litigation. You have a choice. You have a choice to go for that which you perceive to be the least expensive, the most effective, the most efficient, the most fair option for resolving your commercial dispute. So this encourages competition. If I might respectfully disagree with Edward, I think that the gaps, what he called gaps in the model law, gaps in the New York Convention, are deliberately put there. The model law, the New York Convention, definitions of arbitrability, those are they're parts that are deliberately left vague so that the model law, the New York Convention, all the other conventions will usher in a degree of similarity from jurisdiction to jurisdiction, but not uniformity, so that different jurisdictions can compete with each other, saying, come to me because I offer a particular product that is different from, similar enough to, but different from, better than what the others offer. And that is, I think, what will fuel commercial growth and dynamism in the future. The third point, what are the implications for you? The implications for you is we shouldn't be just sitting here taking notes. We should be imbibing the dialogue, the discourse, and we should be going out, as the Secretary General of the Hague Conference said on the 2nd of July, when the Hague Convention came into being. Secretary General said, we've got to sell these conventions. We've got to sell these centers. We've got to sell the mediation centers all around the world so that people know about these things and people can take advantage of them and thereby lower the cost of dispute resolution throughout the world, especially in relation to commercial matters. Thank you very much.
Pick up on that.
Okay. Quick one?
Yeah, quick one.
He's not happy with you. So quick one, yes.
I also disagree with Gabriella at a certain point, but I leave that out.
Okay, I like this, all right? I'm going to have a discussion.
I agree with my colleague that there is a proliferation of arbitration institutions. At last count in Africa, we had something like 72 arbitration institutions. Are they all good at what they are doing? The answer is no. Some of them are not well equipped and they are not competent. But the second point that he makes about costs of dispute resolution. Under the rubric of the rule of law, one element is access to justice. Access to justice itself is a very complex concept. To be able to have access to justice, you have to have access to the beginning, the roots into justice. One important route is through lawyers. Can you afford lawyers? If you can't afford lawyers, then your problem of access to judicial type of courtroom justice is beginning to be difficult. So I don't want to draw it too much, just to leave it.
Okay, thank you for that. Okay, we've got about 5 minutes or so on this subtopic for the audience to participate. Okay, I'm sure you have views as well. We've been talking about changes, sources of dynamism. What do you see are the new things that are coming up which will change the shape of international dispute resolution? Yes, that's Mr. Jeremy Lack from Switzerland. Okay, Jeremy is an IP mediator, arbitrator.
So I just wanted to ask the panel what their views were on two things. One of them was the Global Pound Conference was suggesting mixed modes as a new way forward, the hybrids that you can get. And I was wondering if that is something that could be discussed by your panel, George.
Okay, we will. Subtopic 2 is on hybrid processes. So we can just pause, hold that, and we'll come back to it. Thanks, Jeremy. Somebody else? Something to contribute? Anyone? Come alive. Anyone? Michelle? That's Michelle Kalipatis, QC. All the way from the UK. Mic for Mr. Kalipatis. Someone with a mic? We have no mics. Oh, okay. Sorry, Michelle. The gentleman over there first. Yeah? Next one.
Thank you
Thank you.
very much.
Yes. Introduce yourselves to the audience.
I asked the first question this morning. Jerry Zhang
Yes.
from China.
Right.
I just wanted to touch on the question of conduct of arbitrators and mediators in the future, because I believe this is very, very important. And as we say that arbitration is as good as the arbitrators. So how we can uniformly promote the conduct that is advertised or made public on the website of different institutions, and make it a uniform conduct globally, that bottom line conduct issues that the arbitrator mediators must comply with. This is very important. So I raise a question for you to consider. Thank you.
Anybody?
Yeah, one of the initiatives now being discussed in Working Group 2 of UNCITRAL in the context of the ISDS reform is a code of conduct for arbitrators. Now, of course, arbitrators are subject to a number of rules. They're subject to the rules of the national law of the seat. They're subject to institutional rules, but it is felt that some uniform rules, regulation would benefit to the general understanding of the profession. And so this is being discussed. It could apply, of course, not only to investor-state dispute settlement, but also to commercial arbitration.
Okay, thank you. We take one more question and we move on to the next subtopic. Michelle, do you want to come in now or later? Yep. Can we give the mic to Michelle? Thank you.
Colleagues of mine in Canada tell me that they see the future of mediation governed by artificial intelligence. And they tell me terrifyingly that their colleagues in California who are working on robots think they are simply 15 years away from developing the ability to put a human head on a robot. What does the panel think about the future of mediation conducted by artificial intelligence?
Okay, thank you for that. We're going to reserve this for the last part of our discussion. I think Anselmo has got some thoughts on that. So, Michelle, just keep that. Thank you. Right, we're going to move to the second subtopic, which is about hybrid processes. And I think that's come out. We're talking about arbitration institutions doing mediation, MED up, MED alone, ARB alone. Okay. Some of you may have heard the minister when he talked about, he referred to the Queen Mary's survey of last year. Remember that? Okay, so there was a survey done by Queen Mary's University, and one of the things that came out was very interesting. When they talked about, they asked respondents on their preferred mode of dispute resolution. Okay, and you asked the arbitrators what's going to be the answer? Arbitration, right? And we asked the lawyers, arbitration, as a standalone. Okay, but when they asked the in-house counsel, all right, what's your preferred mode? Can you guess the answer? For arbitration as a standalone, 30-odd%. Okay, arbitration plus some other process like mediation, 62%, double. Okay, so that tells us something. You know, we as arbitrators or lawyers, we think this is what the user wants. The user may want something, and that's a signal to us. And I think we're now at a stage, you said there are many mediation associations, institutes, arbitration institutes. It's about time to look at hybrid processes. What's the choice that you talk about, and what's best for the client, for the parties, and what fits the case best? Okay? You want to kick off?
Yes,
Gabriel?
of course. Yep. There are various points about hybrid methods. we have reached a stage where arbitration has become so regulated and so complex and so burdensome that we're about at the same level like court proceedings, and therefore the users seek more informal ways of resolving the disputes. That is exactly the same reason why they went from courts to arbitration decades ago. Now we need to be careful not to over-regulate the informal mediation, hybrid dispute settlement mechanisms, because otherwise users in a few decades will leave them again. But I thought years ago, when I was a young lawyer, I thought that we need to work towards the real ideal good solution, and once we're there we could rest. But now I'm old and I realize that this is not the way it goes.
Is she old?
You continue.
You're not old, yes.
You continue each time to improve, and you always have to adjust to new changes. So now we're at a stage where we're dissatisfied, or many are dissatisfied, with the heavy nature of international arbitration, and therefore seek new ways. And obviously that is the time for revival of mediation. We see it, and that is why we're here today. At the same time, with mediation, it makes a lot of sense to combine this with a binding dispute resolution mechanism in case the mediation does not succeed. Now, then the question is, how do you articulate the different hybrid modes? One way that has not the favor in most of Western jurisdiction, but does here in Asia or certain Asian jurisdictions, is ArBMed. You start with arbitration and you give powers to the arbitrator to facilitate settlement, if you don't want to use the word mediation. That to me is a very effective tool. It's very efficient because those who will decide whether and when it is the right time to come forward with a settlement approach are those who already know the case. Of course, you could start with arbitration and then have a separate mediation, but if you have a separate mediation, you have to bring in other third party who doesn't know the case, and that duplicates the efforts. Incorporated mediation into arbitration, of course, that means same proceedings, same third party, has a number of risks, but these risks can be addressed if they are properly identified first, and then proper rules and practices are followed. That would probably go too far if I go into the details, but that is at least a suggestion. And I'm always struck how Chinese arbitrators do mediate and understand it as a normal thing to do, and we could certainly in the West learn a lot from this practice.
Okay, thank you. Selma?
In this segment, we're looking at the medium term. What are the sort of changes, particularly in terms of hybrid dispute resolution, that will take place in the medium term, given the sources of dynamism described in the first part? In the first part, I had comments about competition between different modes, for instance, of dispute resolution. But in this part, I think one should also focus not just on competition, but on complementarity of different modes of dispute resolution. In that context, I think that there will be greater emphasis in the future on hybrid dispute resolution. Look what's happening in terms of platforms. Various jurisdictions, Hong Kong is one of them, are working on creating a platform, a one-stop place where you can go and get an arbitrator, where you can go and get a mediator, etc. Perhaps even go to court, for instance, the China International Commercial Court, to deal with your problem. with your case, with your dispute. Perhaps some bits can be hived off to arbitration, some bits can be hived off to mediation, some bits may even be hived off to litigation. One of the problems that I've had with this platform is how is the platform going to allocate to decide which parts of a dispute, especially a complex commercial dispute, goes to or is attempted to have a resolution by arbitration or mediation or litigation? Who's going to make that decision? Is it going to be a court? Is it going to be an arbitrator? Is it going to be a mediator? I think what this suggests is the platform alone, an electronic platform alone, will not be sufficient. What will probably arise in the short to medium term are hybrid dispute resolution service providers, or for short, HDRSPs. And the idea here would be much in the same way that today we have contract clauses that nominate resolution by arbitration or designate resolution by mediation followed by arbitration or designate a choice of court by choice of court agreement. In the future, we will be designating, or the parties will be seeking to agree on a panel of HDRSP. So you'll have an HDRSP clause rather than an arbitrator clause or a mediator clause or a court clause, a choice of court agreement. You will either agree or will have some mechanism for appointing someone who will then decide, or a panel which will then decide, which bits of a dispute will go to which parts for resolution. It may be that they will listen, due process, to what each party has to say if there's disagreement about which part goes to which, but then they'll direct how a dispute, a complex dispute, might more efficiently be resolved. Now, if that's correct, if that crystal ball gazing is correct, what are the implications? In terms of education, and perhaps that's the one implication I'll discuss, I wonder if our law schools at the moment focus far too much on adversarial dispute resolution and teaching law as something that is adversarial, rather than approaching law as something that is interdisciplinary, not just relating to law, but interdisciplinary, and an interdisciplinary attempt to try to get students to find, to think of, to rationalize ways of resolving disputes. Not to win, but how to resolve disputes. And perhaps that's what our law school curriculum should be focusing on. I'll have more about this and the implications of AI in the third part, but I'll leave it there for now.
Okay, so that's interesting about changing our law curriculum, that to churn out problem solvers as opposed to litigators or arbitrators or mediators. Look at it holistically, what's best for the client, what's best for the case. So I think we would like some responses from the audience on this, but let me hear from Edward first, and then we'll take questions. Yeah.
Thank you.
Just try, maybe talk about this point about...
Yes, indeed.
Yeah.
First of all, the law doesn't change very quickly or readily. Once a piece of law or legislation comes into existence, it has to be tried and tested. How do you do it? By implementation. So you have to make time to apply the new law or the existing law to see how effective it is in serving the community where that law is. That's point number one. Point number two is this. In my interactions and activities in England, I do know that mediation is working very well in commercial disputes. I emphasize commercial disputes. Is working very, very well and quite successfully. It is perhaps in England, I dare not say so, but I believe mediation ranks a little bit higher than arbitration. The converse is true in Africa. In Africa, ironically, Africans work with negotiation and conciliation, which is a form of mediation. So negotiation and mediation are common events in Africa. But here again, they are common with certain types of disputes, like family disputes, like boundary disputes, and more recently, in political disputes, I'll have you know. So mediation is there operating at these particular areas, but not commercial arbitration where you've got big business and big money is involved. Those go to the court for litigation. So the combination of ArbMed or MedArb in Africa is not a thing yet to, if you like, to say that it has gained currency. It hasn't. Litigation is also very paramount in the way things operate in Africa. I think this is because of the lawyers. A lawyer's first indications, if you go to see a lawyer, is to find out how soon they can get you into court, because the courtroom lawyer is the lawyer. In fact, if you're doing things like conveyancing and other things, commercial things in your offices, I mean, nobody hears about you. But if you're wearing the wig and gown and you go to court with a bit of a flourish, how to address judges, the audience is listening to you, this is great stuff. So the mindset is the lawyer is the court-going lawyer. Now, that is where the difference is. It means that the ordinary folk are tuned to the fact that going to court is the way to find finality to your dispute. It doesn't help that at the end of the day, you go to mediation, and if the parties don't agree with the final, if one side doesn't agree with the final result, then you have to start a different process. Arbitration, too, despite the principle of finality of arbitration, in the areas that I function in Africa, finality is a very, very difficult stage to reach. So finality in arbitration is not a foregone conclusion at all. These things are drawbacks to how the processes that are operating in the domains that I'm familiar with, how they are operating, whether satisfactorily or not. And the final point about it is that once we are giving the systems, we tend to hold on to them, and we don't want to change them too quickly. So it rolls back to where I started from. The law, once it comes into place, must be given time to mature and for the systems to be implemented. Without that, you haven't done very well. And you have to change the minds of the users to tune them to the fact that the law is not the only way to look at things, but you can do things through negotiation, mediation, and the other easier forms of bringing finality to your dispute.
Thank you. Okay. Michelle, you want to come in now? And then Jeremy, and then we move on to the third topic. Yes.
May 2 points, please, if I may. Picking up what Anselmo said, the greatest advance, as far as I'm concerned, has been the ICC competition, which has been running now for 12 years, where students from all over the world are demonstrating mediation techniques in this competitive atmosphere. And my sincere hope is that we started with 12 teams 12 years ago when I was one of those starting it. We now had 84 teams last year. My hope is that there's a whole generation of lawyers who are learning exactly what Anselmo said, that there are more ways than one of resolving a dispute than slugging it out in court. And picking up, if I may, what Gabriela said about MedArb, I do MedArb, but I do it in a rather special way. I think it's very difficult to be an arbitrator and then switch to being a mediator, because parties will be conscious that at some stage you are going to be making a decision, and they will be cautious about what they say to you in the caucus meetings that are an essential part of mediation. More effective, I find, is to have a MedArb, have a mediation, get to a settlement. But most settlements require further documents to be signed, agreements to be entered into, properties to be transferred, shares to be transferred, and doing all that in one day in a mediation is a recipe for disaster and suing lawyers for getting things wrong. And so what I've adopted is a system whereby there are binding heads of terms which the parties sign up to, and there's a mutual undertaking to implement by signing such documents, entering into such agreements to give effect to the binding heads of terms, and both parties also undertake that in the event of any dispute as to the form of, or the content, or the necessity for any particular document, they appoint me as the arbitrator. So I'm deciding a very simple point: does this document meet the requirements of the binding heads of terms? That way, I'm not compromised by anything I've heard in caucus. On the contrary, I know exactly what the intention of the parties is, and therefore able to resolve the dispute between the lawyers who are arguing over how to give effect to it.
Okay, thank you for that, Michelle. I will tell you in Singapore, the take-up rate for ARC-MEDUP is on the increase. The way we do it here is, you've heard of SIAC, right? SIAC, the Arbitration Center. SIMC and SIAC are sister companies. So when we started a protocol 5 years ago, and for enforceability issues, because we didn't have this convention then, and you're right, people are concerned about finality. So for parties who are concerned about finality and enforceability, we said, fine, register your case with SIAC as an arbitration. Initial papers filed, then the protocol says you stay the arbitration, you go for mediation at the SIMC, separate person, mediator would not be the arbitrator because we think there are different skill sets involved. Okay? If you settle, you can convert your settlement agreement into an arbitral award, which is enforceable in 160 countries. So that's what we did before this convention came about. And that's proved to be very successful. I think there's a lot of traction. And if your case is not successful, then you go back to arbitration, you carry on.
Yes, I understand.
And so you've got finality for the parties, for the client.
You told us that we could interrupt.
Yeah, so that's something which you may want to think about, okay? Right, I got Jeremy and then somebody at the back there. Okay,
But
hang on.
I want to
Yes.
stay on this at some point.
Sure.
You said we should interrupt.
Sorry?
You told us before when we prepared that we should interrupt you.
Okay, all is gone.
No, I can hold.
I know.
Let's
Let's hear from
listen to
Jeremy. He's been waiting.
and
Come, Jeremy.
Pick it up after.
Yeah.
So just more of some thinking about what is going on. And one of the colleagues in the room this morning from Singapore, who's a non-lawyer, was challenging the question of are lawyers detrimental to trying to resolve cases. When you have a commercial dispute, there are normally two ways of thinking about it. Do you want norms to apply, or do you not want norms to apply? And the whole logic of bringing in lawyers, the whole idea of bringing in an arbitrator, the whole idea of bringing in a conciliator is to say we need somebody to help us understand the norms and to apply the norms. The logic of mediation is there are no norms necessarily. It's subjective interests. Let's look to the future. What motivates you? And so it's a kind of a schizophrenic exercise to some extent. Do you want norms? Do you not want norms? Do you want both? So if we come back now in this context to the notion of hybrids, one of the problems that I see is that people are saying, okay, you can do arbitration, you can do mediation, choose either or. And I'll push you a bit, George, for Singapore. You have two wonderful institutions, SIMC and SIAC. But you've still got to choose between them to some extent. Which one do you want, norms or non-norms? All right? So that's one way of, silos. In France, the CMAP has two systems, and you're not allowed to do, there's a Chinese, maybe the wrong word to use, but this wall of separation between the arbitral procedure and the mediation procedure. So that is in parallel, but watertight, sealed off from one another. Then you have the sequential logic, and Michelle and other colleagues who I know are very good at starting with mediation, moving to arbitration, because they have the capacity to do both adjudicative work and interest-based, non-norms-based work. All right, but that's sequential logic. Challenge to you is, what about saying you want both? You want both, you want a mediator and an arbitrator sitting together, and you want them to work with you on designing the case. You want SIMC and SIAC to sit together and give you two people working as a team so that you can work out what norms we want to apply, when do we not want to apply norms, and we will tailor the process for you to get you justice in a faster, cheaper way that touches on the notion of accessibility to justice.
Okay, that's very interesting. All right, that means the arbitrator and mediator working together to see what's the best way to resolve that dispute. I see a lot of hands now, so we're getting hot. Very good. That gentleman over there first, Marcus. Yep.
Thank you.
And then I'll come to you. Yes.
I come from Indonesia.
Right.
In practice,
Selamat pagi. Selamat petang.
you.
Selamat tengah hari.
Terima kasih.
Okay.
In practice, sometimes we come across the word besides mediation, also conciliation. Something they put mediation/conciliation. No, Actually, what is the difference between conciliator and mediator? Mediator is supposed to mediate the differences. Yeah? Conciliator try to conciliate the people. So in this case, the matter, when we refer to the convention, does the mediator also function as conciliator, try to conciliate the parties or not? That's one. Number two, in Indonesia, it's more practice, the preference by the parties concerned. They like to have the hybrid arbitration. Yeah? Of course, the problem comes if it comes to the phase of mediation. The parties can, of course, appoint the mediator, but if they agree, because the ultimate aim of the party is to come to an agreement, to a solution of the party, they may agree to ask or to invite the arbitrator eventually to act as mediator. That's the practice. Thank you.
Okay. Do you need an answer to that, or is that a statement? Do you need an answer?
Yeah, about
You need.
constitution.
You want to? Anybody? He's saying, should the mediator also do conciliation?
Well-
Okay, so for the audience, I think there are different there could be different understanding of what conciliation is. Okay, the general understanding here, and I stand to be corrected, is that in conciliation, the conciliator sometimes suggests outcomes. Am I right? All right, so that goes a bit further than mediation. That's my understanding. Anybody else with some violent objection to that, Gabriel?
Can I add to this?
Yeah, okay, can you answer that, Edward? Yeah.
Yes. I think there is a question of terminology here. You would know that ANCITRAL, under whose auspices we are conducting this conference, ANCITRAL now is working on the mediation rules, what it calls mediation rules. But ANCITRAL has always had ANCITRAL conciliation rules. So on a previous occasion, I asked the Director General, who was here yesterday, I don't know whether she's in this room now, I asked her to please clarify, because the term mediation is gaining pace in various countries, which means that ANCITRAL had a problem with reconcile what is coming out as mediation with the existing ANCITRAL rules. Now, yesterday when I encountered her, she said she will give me an answer soon, so I'm waiting for that answer. It is a question of terminology. There are those who say that the terms are synonymous, and they can be because the ingredients, the elements are similar. But if you like to be a little bit classical about it, you might begin to find differences of the sort which
Okay.
Okay.
Okay, I am really sorry. I know there are a few hands. I got to move on to the last subtopic, and we'll try and find some time for you all. Okay, Marcus and this young lady here. Young, right? Yes, okay. All right, we've got 18 minutes, 28 seconds. Third subtopic, which is about AI, ODR. Okay, Anselmo? Your pet topic, right?
Well, I've been looking into AI and artificial dispute resolution over the last month in preparation for a paper I'll deliver later this month in Taipei. But some thoughts I've had. I initially told a friend of mine, who was a mediator, who has done many thousands of mediations in Hong Kong, that his days were numbered. Because once you have AI, and AI is predictive, it will, let us say you come up with an AI that can predict with 70 to 80% certainty or probability that this is going to be the outcome of a dispute, let us say a commercial dispute. Well, once you have that, I said, why do you need a mediator? You know exactly what the optimum deal is for a particular party. You get the expected value of litigation, and so you make an offer close to around about the expected value, 70% times the stake being asked for. I've since thought about that, and I think I'm wrong. The mediators in this room need not fear. They will be needed way into the future, even beyond the 50 years. One, in other conferences, what is constantly being stressed is the need for a human face. So I'm not sure that that human face can easily be replaced. The machine can tell you 70% probability this is going to be the outcome. But the client is going to say, so what? You tell me why I'm not within the 30% error rate. And it may need a human face. Now, recently, very recently, there has been a mediation conducted, I believe, solely by AI. The AI mimics the human being. And that may be satisfactory to some. I'm not sure it will be satisfactory to everyone. That's the first point. The second point is this. I'm assuming, in all that I've just been saying, that there is one AI. But in a marketplace where you have competition, there will be many AIs. Different companies will be putting forward different products and saying, use my AI, because I've got a superior database. The other company will say, oh no, that database is extremely biased, because the information that it has that has been input into it is skewed towards certain types of cases. So why should you rely on that? Rely on our unbiased AI instead. People will be competing. One side will say, my AI says this. The other side will say, my AI says that. It'll be very much like one party saying, my lawyer says this, and the other party saying, my lawyer says that. It may be a springboard in terms of mediation for reality testing, but it's not going to do away with the mediator. The final point I'd like to make about AI, and not just mediation, but all forms of adjudication, litigation, and arbitration. What are the ethics of it? Not just from the point of view of designing an ethical AI. There's an EU ethical charter for AI at the moment, AI design, and ethical design for AI. No, I'm not interested in that. I'm interested in the ethics from the point of view of the judge or the arbitrator. The AI is put before me as a judge, and the AI predicts with 80% certainty that this will be the outcome. I'm a tired judge. I'm an old judge. I've got a lot of KPI to produce. I've got to do a lot of cases. Yes, I know it's dangerous. I've got to verify what the AI is about, what the inputs have been, because it's simply predictive. It doesn't do reasoning. It's machine learning. It finds patterns, but I've got to look at the underlying pattern. But when push comes to shove, am I going to do that verification? Am I not just going to say, well, the AI says this? And that's looking at a whole number of cases. That's the 80% likely outcome. Who am I to challenge that? Why don't I simply do it? And then I'll say in my judgment, I looked into the potential bias in the inputs, and I found out I'm fully satisfied that the outcome of AI is appropriate. What is to guard against a judge or an arbitrator doing that? And that's what I'm concerned about, and that's what I'll be discussing in Taipei, if you happen to be around there. What are the ethics of the judge or arbitrator using AI? What are the safeguards? Or if you want to use modern technology or modern terminology, what are the nudge and what are the sludge factors, the incentives and the disincentives that can be put into the system to ensure that judges and arbitrators are kept honest and do not just blindly rely on the patterns found by AI?
Okay, thank you, Anselmo. We've got 12 minutes left. I'm going to have quick points from Edward and Gabriel, and then the rest of the time is yours.
Quick points
on AI and ODR.
I think I yielded space time to Anselmo, because I said I don't really do online arbitration. Okay. But my point about it, hearing what he's saying, is that I'm going to be futuristic about this, because I know that the School of Oriental and African Studies in London, with which I work quite closely, has been doing arbitration conferences. We've had 4 such conferences in Africa, in Cairo, in Lagos, in Kigali, and the 4th one, where were you? Addis Ababa. since 2015. And I heard the word design from Anselmo. I think I'm going to pick up on it and sell the idea to this great institution. The institutional support is a training, well, I think you know that it is a university, so as University of London is a university. So I can work with them on this and invite Anselmo to come and talk to us over there so that we can design and make use of it for our future conferences. Thank you.
Thank you, Edward. Gabrielle?
Yes, as a reaction to Anselmo, how do we know that the human judge will get it right? I mean, more right than the AI, which has a 70% chance. Does the human judge...
Be careful, there are two Singapore judges sitting there. Justice Chow and Justice Lai.
Let me say
Both senior judges.
Let me say the arbitrator, right?
Yes.
And then nobody...
Okay,
Could I respond
we'll
to
hear
that?
from you after as judges.
Could I respond to that?
Yes.
My paper that I'll be delivering in Taipei also deals with this, because the human being is subject equally to prejudices and biases. Would you not be more comforted by an AI that, although unfeeling and unreasoning, spots the pattern in a huge amount of cases input into its database? Some may be satisfied by that, but here is a behavioral aspect. It's something about human beings. We may prefer the comforts of the human face to the perfection of the AI. That is, perfection may at sometimes be the enemy of the good. There is a human element to dispute resolution. Not just mediation, but I think also arbitration and litigation. We've talked about the conflict inherent in ArbMed and doing it at the same time by the same person. Nonetheless, my studies, we've had a conference on this in HKU, Hong Kong University. Our studies suggest that there is a strong urge in different cultures all over the world to have MedArb, to have a means of dispute resolution by the same person, even though there are inherent contradictions in that. There is a strong urge, and I think, I've thought about it a lot because it seems irrational, and I think it's because we're not just about getting the right or legal result, we're also about getting things off our chest, saying why we think that something is or is not unfair, however irrational we may be. And that is, I think, also an important part of dispute resolution.
That may be a difference, for instance, if you look at the progress in medicines. We will have machines that operate on our bodies and probably do it much better than a human hand. And if I have the choice, I take the machine because I know the machine, I have greater chances of surviving with the machine than with the human doctor. But in dispute settlement, this would be different, you tell me. Maybe we have to think about these things.
We have to study it.
Yeah,
okay.
yeah.
I'm afraid not enough
All right.
empirical studies.
We've got 8 minutes left. I promised the audience. Now, Marcus, and then there was that young lady here, and then this gentleman here. And okay, Brad, judges, you want to respond? No. Marcus, yep. Mike, please.
Hi everyone, my name is Marcus. I'm the Executive Director of the Singapore International Mediation Institute. And I just wanted to say, first of all, when Mikhail said that ICC had 12 teams 12 years ago for the first competition, it gives me a lot of hope because this year, SIMI did our own competition and we had 40 teams. So the world is really changing and we're looking forward to, oh, thank you. Yeah. Thanks.
Okay, great.
Yes. And of course, all the lovely participants are here as well.
Okay.
So we're very happy for them. My question to the panel is, regardless of AI, hybrid, whatever the future brings, how do you feel about a standards body taking on a bigger role, a leading role in not just promulgating, but in a sense, soft regulating, so that users will be assured of standards regardless of whether it's hybrid use, or AI use in mediation, whether in Singapore or elsewhere? So it's a real question. It's a question for the panel. I'd like to hear from them. Thank you.
Okay, anyone?
Soft law.
It's talking about light regulation of mediators to uphold standards.
I think the question said something like referred to soft regulation, which I understand to mean soft law, so guidelines, practices, best practices, articulations of that. I think that is necessary, and I think that should be done now in anticipation of the future. Let's not wait. There are problems with hybrid dispute resolution. There are problems with HDRSPs. There are problems with the use of AI, and we've just highlighted it. There are problems with ODR. But these, I believe, will be inevitable in the future. In order, if anything, to cope with a heavy caseload or commercial load of commercial disputes going on with multilateralism, with the growth of globalization, so we have to deal with it in any event. So we should be preparing now and discussing this. I should also point out that Singapore...
When I say soft regulation, I don't mean just guidelines and practice, because that has no teeth. What I meant is that we get the buy-in of the partners. In a sense, we audit them, and they agree to join us because they adhere to those principles. So not just a you may follow, you may not follow. It's a join us as a partner because you commit to these standards. So it's a bit different, yeah.
Well, Gabriela shrugs. I'll leave her to answer it.
No, a partner for what? I mean, who is the partner?
A partner with an international standards body like us, like CIMI, or any one of our other members of our alliance, like IMI or ICFML. So any organization that promotes standards in mediation. You join us as a partner, you carry our logo. It's a symbol of trust and assurance to users. So that's what we're talking about.
So the partners are other organizations.
Yeah, you subscribe.
Fine, sorry, I apologize. Yeah, that's certainly very good.
That's fine, I think, yeah.
Now, will it be sufficient? That's a different question, but it's certainly a very good initiative.
Okay, good food for thought, Marcus, thank you. Yes, I promised her, yes. You got to tell us your age first. Sorry.
Nodra B. Majid, Pakistan. Mr. Lim, may you always wear glasses where you see people younger than they are.
Okay.
My question is, how, to everyone on the panel, how would you conduct this discourse on the present or the future of mediation in countries, or let's say less stable economies, who have not even overcome their reluctance or their distrust of international arbitration? So, for example, we have been trying in my country, Pakistan, to convince the government for over 10 years to reform the arbitration laws. How would you suggest we now incorporate this new mechanism of mediation into that discourse? Do we say that forget arbitration now because it's too legalistic and let's move to a new form? Or do we say make it complementary, in which case the government, who's already firefighting, as a lot of in these countries they do against opposition or immediate neighbors and whatever domestic issues they have, they'll say, what, we have now two different methods that we need to train in. So how would you propose to suggest a way forward in that situation?
In Pakistan, you have to learn how to play cricket first, right? You have to learn how to play cricket first. Yes. Anybody?
Yes.
Your Prime Minister, that's the way to talk with him, I think. Yes?
Yes, I can respond to that.
Anybody wants to answer?
Yes, I can respond
to
that.
Sure. Yeah.
That's a very interesting question because I think so far the emphasis has been on arbitration as an ADR segment. But the Chartered Institute of Arbitration, the English variety which we've adopted in Africa, has started training courses in mediation. So under the umbrella of the Chartered Institute training courses, you have arbitration courses and mediation courses. Because I can see that mediation is actually advancing. It is getting itself known. And as I said earlier, it's working very well in England, except that the areas of dispute that mediation in Africa covers are confined. Once you open them up into commercial mediation, then I think we'll have a very important development, a major development in the use of mediation in the developing world.
Okay, thank you. One more, sorry, and then we've got a minute left. Yes, quick question. Sorry about the rest, sorry. Just one more.
Hi, Rahim Shamji, CEO of ODR International from the UK. My question's about hybrid and education and talking about AI in particular. We focus our market base on the sub-35 group of people around the world. And when we talk to this group of people, when we're doing mediation, arbitration, and negotiation training, and we talk about technology and AI, there is no fear whatsoever. They, as a generation, look at AI, and we're already in the AI world. From surgery and medicine to accountancy to diagnosis of cancer, the predictability is going up all the time. And as you said, interestingly, is what you feed into the machine is what you get out. And the same thing is happening with human beings. But what we do find, interestingly, is this concept of reasoning that humans have that machines don't have. And I'd like to suggest to you that a hybrid process in AI is the future, not AI alone.
Okay, thank you. We're going to run out of time, so I'm sorry we won't have time to answer that, but perhaps you can take this offline. I just want to take this opportunity to thank our panelists. Please give them a hand. Yep. Food for thought for you. We've got a lot of new structures. We've talked about Singapore Convention, we've talked about New York Convention, we've talked about choice of courts, the Hague Convention, and international commercial courts, many new structures. We have choice now, okay? And I think Anselmo gave us this idea, maybe we should be looking at dispute resolution as a whole. What's best for the client, how to solve the problem. Lawyers as problem solvers, okay? And finally, technology. I think we shouldn't be afraid. AI, ODR, let's face it. But I agree, Anselmo, the human touch is the most important, okay? And I think we'll have a place in mankind still. Thank you very much. Yes.
Well done, well done.
And ladies and gentlemen, Mr. George Lim did indeed bring that human touch. Let's give him a big round of applause. Thank you.